Welcome to Business Line's State of the Economy podcast, where you'll find insight, analysis, and the story behind the numbers.
Hey there, welcome to the BL State of the Economy podcast. I am Shrivats from Business Line, and today we have a very interesting topic at hand, which is a deep dive into deal value thresholds. The Indian Competition Act governs mergers, acquisitions, and amalgamations to prevent anti-competitive practices and ensure fair competition. Traditionally, the Act uses asset and turnover thresholds to determine if a transaction needs to be notified to the Competition Commission of India. However, this approach has faced criticism, especially with the advent of digital markets, where high-value transactions may involve companies with low tangible assets or revenues, potentially escaping regulatory scrutiny. To address this gap, the Indian government had introduced the concept of deal value thresholds through the Competition Amendment Act 2023. So, what are DVTs? DVTs, put simply, are those transactions which above a certain deal value have to be notified to the CCI regardless of the asset or turnover of the companies involved. This aims to capture high value transactions in the digital and other sectors where companies like startups might have high valuations due to data or intellectual property but low traditional financial metrics. So, what are the issues and concerns around introduction of DVTs in India? What implications would this move have for oversight of digital markets in India? Does DVT have implications for other sectors too? To help us better navigate the various issues around deal value thresholds and its implications on regulation of digital markets as well as other sectors by the Indian competition authorities, we today have Dinu Muthappa, a partner at the Delhi office of law firm Talwar Thakur and Associates and a member of the firm's competition law practice. With almost 15 years of practice, Dinu has advised clients in complex competition law issues including abuse of dominance, merger control, cartels and leniency, antitrust litigation, and compliance across various sectors including digital markets, pharmaceuticals, healthcare, media, and FMCG. Dinu is involved in a number of high-profile abuse of dominance enforcement cases, including several investigations into the digital markets. Dinu, who obtained her LLM in competition law from King's College of London, is also one of the few practitioners in India to have worked with the CCI from the year 2015 to 2017, where she served with the office of the chairperson. Welcome to the BL State of the Economy podcast.
So, thank you so much, Dino, for joining the BL State of the Economy podcast. Today, we have a very interesting topic at hand, which is a deep dive into the world of deal value thresholds. So, Dino, for the benefit of our listeners, can you help us understand what are deal value thresholds and how do they differ from the existing merger control thresholds under the Competition Act?
Sure, Shrivats, and thank you very much again for inviting me and looking forward to this deep dive. How the current regulatory framework is set up is that today, under the current competition law, there are certain transactions which have to be notified to the CCI for its prior approval. The basis of catching these transactions, which one has to notify to CCI, is based on the value of the assets or the turnover. That is, it is by reference to the size of the parties, which will determine whether or not the transaction that that party enters into has to be notified. And that size can be with reference to domestic as well as global numbers. So this is the current regulatory framework as it exists today. In 2023, the Competition Act was amended, which introduced a number of novel changes to modernize our competition laws. One of these changes was the introduction of this deal value threshold, or what is colloquially now called as DVT. The DVT is now contingent on the transaction size or the amount that an acquirer is willing to pay as consideration in order to determine whether that transaction has to be notified to the CCI. So let me just explain this. If a transaction exceeds 2000 crore in value, you will have to notify the CCI of that transaction for its prior approval if the target that is involved has substantial business operations in India. The intention of this DVT, deal value thresholds, was intended to bring within CCI review those transactions where the target value may not be significant, the value may be disproportionate to its actual assets and revenue figures.
Got it. So how does it help CCI?
Sure. So DVT, what it does is that it will enable CCI to now scrutinize transaction based on the monetary worth of the transaction. The current framework as it exists, like I had mentioned, is based on assets and turnover. And these were set up as indicators of the relevance or the competitive significance of a business. And in traditional businesses, arguably, the value of assets and turnover are sufficient indicators that the target and the acquirer are large enough for the CCI to look at it. However, in the modern economy today, especially in these new age markets, there can exist a disparity between the size of an entity and the competitive relevance of an entity. Therefore, what the CCI will now look at is how much is an acquirer willing to pay a price of that to acquire that target, especially where the value that the acquirer will ascribe to the target is totally disproportionate to its assets or its turnover. So typically, certain transactions in the tech space where the target itself may have very little asset or very little turnover, but the acquirer is willing to pay an enormous amount of money for the acquisition of that target. These are the transactions that will now be caught within the introduction of DVT.
So that begs the question, why do we at all need DVT in India?
So over a period of time, it was felt from a policy perspective that there are these high value transactions which are very competitively relevant, but they are escaping merger control scrutiny because the traditional threshold is assets or turnover of an entity. A lot of these, especially in these new age markets, the targets were following below the value of the asset or turnover which is needed to notify CCI. So a number of these transactions were falling outside the scope of the CCI review. And let me take an example. For example, Flipkart's acquisition of Myntra. That was a transaction where Myntra arguably would not have had high value of assets, right? It's a digital company. It does not have high assets. And therefore, it would fall outside the merger review of CCI. But the value of that transaction, the consideration value was in fact 2000 crore itself. Right. So I think from a CCI point of view, it was to ensure you have an additional criterion where you're looking at the monetary worth that an acquirer is willing to pay. And the idea is, I think, to target a couple of different scenarios. One is those transactions which serve as a strategy for market consolidation, or let's say that there are these killer acquisitions, elimination of a potential competitive threat, or even where an acquirer wants to expand into a new line of business. These kind of transactions, the intention is that the DVT will capture them and bring them within CCI review.
Got that. So now the point is the concept of DVT or the DVT threshold specific only to tech companies, and how do they overlap with the existing or the proposed digital competition bill?
Sure. So, in fact, Shivats, it was actually some of these unique characteristics of the tech industry which played a huge role in identifying the need for this deal value threshold. But that said, this DVT is not restricted to tech companies. It's not restricted to the IT sector alone. As it stands today, the threshold is sector agnostic. And aside from tech companies as well, there are other markets where these thresholds will become very relevant. For example, let's say in a pharma sector, in a financing business, or even in the case of these so-called killer acquisitions. In these cases, also DVT will play a huge relevance on these transactions moving forward. Now, as regards your query as to whether there is an interface with the Digital Competition Bill, very recently, this draft digital competition bill was released by the ministry for comments. And what that bill does is that it proposes certain sweeping measures to regulate the behavior of large digital gatekeepers. The bill in its current form doesn't contain any provision on DVT or on merger control specific for technology companies. And the reason was this, that actually, prior to this bill being released, we had the Competition Amendment Act of 2023, which was passed. The Competition Amendment Act 2023, which was passed, brought into and introduced the very concept of DVT. And therefore, in fact, the committee which proposed this draft digital competition bill has recorded that it felt that given that the DVT addresses all these concerns of these killer acquisitions in the technology space, there will be no specific merger control or no specific sector-specific merger rules required for large tech companies. So everything as it is will now be regulated by this deal value threshold, which, like I mentioned earlier, will be a sector-agnostic rule.
Got that. So now the Act has introduced a 2,000 crore deal value threshold. So a natural question that will arise is, how do you calculate this actual deal value for the CCI notification assessment? Given that there are so many creative ways in which deals can be these days structured.
Sure, Srivatsan. And I think over here the devil will lie in the details. The Amendment Act itself did not provide much detailed guidance on how are we going to calculate this deal value or consideration. Instead, the CCI has introduced draft merger regulations, which will shed more light on this issue. What it has said is that the draft merger regulations, they say that the deal value is defined as any and all forms of consideration which is paid for the transaction, irrespective of its timeline, its mode, its manner. So, for example, in addition to actual direct monetary value, in addition to the direct consideration, your deal value would also necessarily include all other considerations paid for. Let's say, for example, you have a non-compete restriction on the seller, where presumably the value of that non-compete would be inculcated into that deal value itself. Separately, let's say there is a transaction and then there are incidental commercial arrangements that are entered into after the main transaction. For example, in the case of a technology assistance agreement, a licensing agreement, or even a raw material supply agreement. In some of these cases, these ancillary commercial agreements will also have to be valued and included into this concept of deal value to assess if you are exceeding the threshold or not for notification. There are also other certain specific details that the regulations provide. For example, in the case of an open offer, the value will be assuming there is a full subscription of the offer. Even in the case of options, consideration will be assessed on the basis of the full exercise of the option. So, therefore, yes, it will be a little tricky. It may not be as clear as light of day. And there is also, I think, a residuary provision which says that this consideration value should be based on the occurrence or non-occurrence of future events. Now, this may cause some confusion because it may not be feasible today to assess value on an unforeseen or an unpredictable or a future event. And in this regard, I would say the CCI has a merger control division, which has been quite often very helpful to parties through pre-filing discussions. So once this deal value threshold is enacted, we may in fact see a rise of this pre-filing assistance taken from the CCI itself.
Okay, can you also elaborate on this incidental arrangement that you were talking about with an example? How does it play out?
Sure. So let's say that there are two parties that are entering into an investment agreement, and that is the main transaction. But coincidentally, with that main transaction, let's say there is a development agreement in relation alongside that investment. So, for example, Facebook's investment into Geo was the primary main financial investment, but it also contained an incidental joint development agreement for integration of GeoMart. Now, you see, how do you prescribe this value? Because it's based on the future performance of that geomart and that future integration. So today, when I'm entering into this deal, how am I then going to assess the valuation of that future commercial agreement? In some cases, let's say it's a raw material supply agreement, a continued supply agreement for transitional purposes upon an acquisition taking place. In some cases, yes, it may be very clear, but in some cases, the nuts and bolts of it may be a little more nuanced.
Got it. So, what is your take on the point that do these guidelines that are provided are quite extensive, or do you still see some gaps that require clarifications?
So, sure. I mean, in some cases, I think it will be quite clear because it's a very simple metric of assessing what is the purchase consideration. Does it exceed this 2000 crore value? Or even, let's say, in a share swap situation, the estimate shares of the estimate value of the shares which are being swapped or acquired, and the quantum of shares is known beforehand. So, on that basis, consideration may be calculated. And as I mentioned earlier, with non-compete restrictions, also typically the valuation will be embedded within the consideration. So actually, the clarifications in the regulations are a good first indicator, but there may still be some gaps. How do you precisely calculate, for example, value of the incidental arrangements that I had mentioned, especially where you have these arrangements which will run on for years on end after the main agreement? So therefore, the question of how do I look at consideration may cause confusion. Also, this occurrence of non-occurrence of future events, because ultimately you're asking to crystal ball gaze on future options, on future events happening. That may cause confusion. But from a very practical standpoint, Shivats, the way I see it is that we should not be too disturbed by this. One, because there are transactions where the consideration will be very much below 2000 crore. So there's no question of exceeding the threshold or notifying CCR for approval. There'll be those cases where consideration is far above 2000 crore. And then there will obviously be a notification requirement that is triggered. So in my opinion, on a very practical matter, it will be only those intermediate cases where there will be a question as to what all aspects must I consider and must I compute and must I add to the consideration. So in borderline cases especially, the valuation of these kind of incidental commercial arrangements, license agreements, raw material supply, future options, these kind of estimations will be very important for the borderline cases to see whether or not you're exceeding the 2000 crore value. One more aspect I think I would also like to touch upon for let's say in the case of a minority share acquisition. Assuming it's a minority share acquisition of, let's say, maximum of 20% of a company, because financial investors typically don't go that high. It's usually much lesser. But let's say it's a maximum of 20% and that deal value is 2000 crore, which is exceeded. Then what you're looking is that actually the target is valued at 10,000 crores. And in these cases, the CCI believes that such an acquisition must merit competition review. So as a legal advisor, I would say my focus is on the borderline cases. That's where I would think that we would need to spend some time to focus on.
Got it. Now, you also said that, the deal value is not sufficient in itself to trigger DVT, and the parties must also have a significant presence in India. So how have we played on that significant presence parameters?
So you see, the intention here is to capture transactions by basis of monetary worth. Today, the threshold is based on the size of the parties by reference to asset or turnover. But you will have a de minimis exemption, which exists today, which says that if your target does not have sufficient asset or turnover in India, then you can escape merger notification. The deal value also, in a way, is aimed at capturing only competitively relevant transactions for the CCI scrutiny. So, along with the deal value of 2000 crore, the target also is required to have substantial business operations in India. Why this is relevant is because for the DVT, the target exemption is no longer valid, which is that the fact that the target may be very small by assets or turnover is not relevant. But what is relevant is that in addition to the 2000 crore threshold, one must also ensure that the target has substantial business operations. This substantial business operations in India test is meant to be like a safeguard, what we would call a local nexus test. And the explanation of how can you consider a target to have substantial business operation, it has been detailed in the draft regulations. I won't get into the details of it, but the broad way of assessing this substantial business operations is that if your target has 10% or more of its turnover in India, then it will be considered to have substantial business operations. Or let's say it's by reference to its users, customers, subscribers, visitors. If 10% or more of those are based in India, then you will assume that the target has substantial business operations. And any transaction in respect of such a target, the value of the transaction is more than 2000 crore, will have to now be notified. There are, of course, it will still be tricky in terms of some of how this will be worked out. I mean, these are still draft regulations by the CCI. One cited example is that, how do you assess users? If you have 10% of users in India, what is a user? Is it paying users? Is it registered users? Is it by reference to active users, monthly active users? The current draft regulations don't explicitly specify that. And my belief is that it may actually be intentional to leave some discretion and some room for the CCI to see how it may want to play this out. And the CCI may in fact look at maybe other industries such as telecom, how they assess telecom density. They may use those kind of metrics as a good starting point.
Okay, so that comes to my sort of last question to you is on whether DVTs as a concept exists in the competition laws of other jurisdictions, and how has their experience been like?
Sure. So you see, the DVT is, while it is novel and new in India, it is not novel and new under merger control itself. Very recently, Germany and Austria have introduced a very similar kind of test for notification, where in Germany, I believe if you have a deal value of $400 million, and the target then has significant activities in Germany, then you will exceed the notification. Similar provision has been introduced in Austria, albeit with a slightly lower threshold number. In EU and UK, what they have done is they have gone down the digital route, the digital competition route, where they have introduced sector-specific merger control intimation requirements for digital gatekeepers. So there are countries that have handled this and are handling this on a global basis. And therefore, the proposed law here for us in India is aimed at modernizing the Indian merger control regime. And it will potentially bring us up to par, maybe, with how other regimes are also assessing these issues and notifying, assessing, and approving these types of transactions.
So now the question that I have is that what is your overall assessment? Is the 2000 crore threshold level casting the net wide and seemingly very low, even if I were to compare with Germany, what you said of 400 million?
That's right.
Euros. So it looks as if India has set the bar low. Do you agree with that?
No, I wouldn't say it is low, and there are one or two reasons. One, like I mentioned earlier, 2000 crore, an INR 2000 crore threshold is about 260 to 70 US million dollars. The value that an acquirer may be willing to pay for an entity such as that in India may be more relevant. You may have far more advanced Western economies where valuations may be higher, but for India, potentially this number of 2000 crores was considered more relevant. One thing I had noticed is that actually prior to our increase in our merger notification thresholds, you would have to notify to CCI if your parties had assets which were valued about 2000 crore. That was broadly one of the many tests in CCI for notification. This is if the target was not de minimis, if any of the parties or collectively the parties exceeded 2000 crore, then you would have to notify CCI. That number, of course, has since been increased. So I think this introduction of a 2000 crore number is specific and unique, keeping in mind the India context. to me, it is not so much the assessment of the 2000 crore threshold that may need revisitation, but rather the exclusion of what you will consider as substantial business operations in India. Because ultimately, just by virtue of having 1/10 of revenue, 1/10 of users, and what users, right? You can just have, in the context of digital cases, somebody downloading an app and logging in and signing up for the first time. But does that really count towards a user in the traditional sense? So to me, substantial business operations may require some clarification, if nothing else. And since these are draft regulations, potentially we may see some clarification. But the 2000 crore number itself seems to be, from a policy point of view, a well thought out number.
Great. So, Dino, some closing comments on when do you actually see the draft becoming a reality, or when do you see it going live? Is there any visibility on this?
Sure. We had these rules, this provision, which was introduced and passed in the Competition Amendment Act, which was approved by Parliament in 2023. So you've had the law now for some time. And these draft regulations have also undergone a period of public consultation. So subject, of course, to the future priorities of the new government that will come into place, I would say that we could be expecting to see this quite soon after we have our new government in place. So potentially maybe within a few months down the line, if not sooner.
Great. Excellent. So thank you so much, Dino, for all your perspective and helping us take a deep dive on an important topic of DVT. It was great having a conversation with you, and thank you for being part of the BL podcast.
Thank you so much for inviting me, Shrivats, and as always, a pleasure to join.